And I am delighted to introduce Ian Drake. Ian Drake is Associate Professor at Montclair State University, as well as a former practicing attorney. He returns to the old guard with a review of the Supreme Court's recent decisions, also touching upon the politics of nominations and the makeup of the court. Professor Drake is an expert on the American judiciary and legal system, the U.S. Supreme Court, and constitutional history. Professor Ian Drake.
Well, good morning. As was mentioned in the introduction, I am a former practicing attorney, now an academic, and I used to be an insurance defense litigator, for those of you who are attorneys, so it gives you an idea of what I used to do. I left the practice in roughly 2003, 2004, and went back to school to get a PhD, actually in American legal history, and I've been at Montclair State since 2011. So, I'm going to talk about the court today. I want to talk about some of the infrastructure of the court and hopefully touch upon things even some lawyers don't know about the court. I think it's important to understand the judiciary. I try to instill in my students a sense of how important courts, plural, are, but also especially the Supreme Court. I was listening, I was thinking about when all of you were born, as we're talking about these birthdays. Keep in mind, most of my students were born after 9/11. And so their experience is very limited, and alas, unfortunately, their knowledge about much regarding American government is also very limited, not just the courts. And so I want to talk about some aspects of the court, then touch upon some of the most recent important decisions from this last term, and also some of the big cases that we know of so far that are coming up in the 2023 term. I have a PowerPoint slide I wanted to utilize while I speak. So in thinking about the court, I think it's important to understand the current membership. This is a court that's truly multi-generational. These are the current ages of the justices. We've got Clarence Thomas, who is the most senior justice. And as you are well aware, justices can serve for life. Federal judges in our system, unlike state judges, they are able to serve their entire lives. Many do die in office. However, it's common for justices and judges to retire. I am doubtful that Clarence Thomas, he seems to be very youthful, 75, and there's no apparent health concerns regarding him. So I think he's going to serve well into the next administration, whoever that is. Nevertheless, politically, as you know, with Ruth Bader Ginsburg, there was a lot of pressure on her to retire during the Obama administration. And so I anticipate there will be pressure on any justice going forward. I think it's a norm that's going to be established with the Ginsburg pressure to retire if there's a friendly administration in office that might appoint a much younger successor. And of course, the younger generation of the court, all the Trump appointees and Justice Jackson, the only Biden appointee so far, they're all in their 50s. And that is, if recent history is any guide, with medical technology and the lifespan of people today, they could serve for literally another 3 decades. And so these are appointments that really are one of the key legacies of any president. And so it's really important from the presidential perspective who they choose, but politically, of course, the court has become more prominent, and it's seen as one of the most politicized institutions these days. And that's part of the purpose of my talk. Is I want to try to dissuade you from the idea that the court is really an extensively politicized institution. So this is a chart, maybe a little bit difficult to see with the resolution here. This is a chart published in 2017 that covers how the court reviews petitions and grants them. The upper line, the graph on top, measures petitions from 1946 through 2015, the latest data available at the time this was published. And as you can see, there is a significant increase over time in the courts, in petitions made to the court. These are petitions for review. We refer to them in shorthand as petitions for cert or certiorari, which is the granting of a review for cases. The U.S. Supreme Court has a great deal of latitude in what kinds of cases it takes. And over time, these petitions in recent years have risen from little over 1,000 on average upwards. We see a big uptick, a lot of opportunities that lawyers see for potential Supreme Court review during the Warren Court era from the mid-1950s through 1969 and continuing on into the 1990s. And on average, over the last decade, the number of petitions is between 7,000 and 8,000. The number of acceptances, roughly 60 to 80. In other words, you have a roughly 1% chance of having your case reviewed for those petitions that are submitted. In recent years, the number of petitions has gone down considerably. There are a variety of reasons for this. You may have heard of the so-called shadow docket, which is actually a separate docket of particular appeals that are usually, as a case is ongoing, it hasn't been fully decided on its merits, and there is an effort to have a superior court review a portion of the case and potentially affect the appellate outcome. And this is the so-called shadow docket. It's not a full so-called merits review of the case, but rather a review of a particular issue, sometimes referred to as an interlocutory appeal. Nevertheless, that may have reduced the number of overall appeals, but it's a huge number, and the odds of getting reviewed really are minuscule. The court has a great deal of latitude in terms of the cases it chooses. Often a case will come to the court because it's seen as being a really important case that will shape American law, but not necessarily be politically important. For example, the abortion decision is actually pretty rare. The Dobbs case from last year, the UNC and Harvard cases from this term, these are pretty rare in terms of their political salience. There are a lot of cases that fly under the radar from media coverage. Again, on average, between 60 and 80 cases are heard every year and decided on the merits of the case, meaning the legal substantive law is questions are resolved. Very few of these are covered in the national media, but they're important in whatever category of law is being dealt with by the court. So in terms of recent petitions, as I mentioned, they've gone down. 7,000 is the average, and that benchmark has gone down ever since 2015. So that article that I referred you to with that chart actually gives a misleading impression that it's an ever ascending number of cases that are being asked of the court for review. It's actually declined recently, and this is for the 2022 terms. You've seen it go down to just under 5,000 petitions. That makes the workload of the court a little easier. Keep in mind, there are 9 justices, and reading 7,000 to 8,000 petitions per year is virtually impossible. So they have a bevy of clerks. Each of them at least has 4 clerks that work with them. I want to describe the clerks and their jobs in just a moment to give you a sense of how the court does its business. But these have been referred to over the years as little law firms. The court is close in terms of its interpersonal workings among the justices themselves, but also their clerks. Clerks are usually recent law school graduates. They're usually in their mid-20s or early 30s. This is often their first law-oriented job after law school, and it's a real plum position. It helps them in their future careers. They usually establish a good working relationship with their justices, and there are feeder networks that have been established over the years. Conservative justices tend to have conservative feeder networks. They know law professors in law schools that will scout out potential clerks and recommend them to them. Same thing with the liberal justices. So often the clerks are in ideological and political alignment with their justices. Doesn't always work out that way, but nevertheless, it's pretty typical because of the feeder relationships that they've established. The clerks do a really important set of jobs for their justices. They are the ones that are reviewing these many thousands of petitions. They divide them up among the clerks, and those clerks are the first eyes at the level of the Supreme Court to assess the potential merit and importance of cases that are being petitioned for review. And so they can really shape how the justices see the cases. And it's seminal work. Again, these clerks are young people. They're smart usually, but they may not have a great deal of perspective that comes from experience. And so the clerk's positions, they've been evaluated over time as being too important to be left to these relatively inexperienced people. But this is the system that's been established. It's notable that the clerks only serve for 1 year. So they don't develop a body of experience in this position. They come straight out of law school after 3 years of legal education. They do the clerkship for 1 year, and then they move on to their future careers. So there's a new bevy of clerks right around this time every year. The old clerks are leaving, the new clerks are coming on, and they are reviewing petitions just like their predecessors. And so they perform a really important function. The other big function they have is they're often the initial drafters of their respective justices' opinions on cases, whether it is a majority opinion, a concurring opinion where the judge or justice agrees with others in the majority, or a dissenting opinion where they voted against the majority. The clerks are often the first drafters of that. Obviously, what is ultimately published is done so under the imprimatur of that justice, but we have had historical instances where initial drafts have later been made public, and they've been changed very little from what the clerk initially drafted to what was ultimately published under that justice's name. So that indicates the clerks really are doing an important job for each of these justices. This is a chart. I apologize, it's a little hard to see with this resolution. This goes back, this starts in 2015, and it goes all the way back to 1803. And the point of this chart is that what we're trying to gauge here is how often the court's justices are in agreement with one another. And this is one of the main points that I want to emphasize about the functioning of the court. There's a perception. It's no accident why this perception exists. It's because of current media coverage, and I don't just mean current of recent years, but this is the way the court's always been covered ever since the Warren Court especially, or really the New Deal Court, is that this is a court divided by conservatives and liberals, and that they are often at odds. I don't think that's true at all. I think you only see it in a very few cases. The most notable ones, of course, which reinforces this perception that it's a politically contentious institution. This is a chart that measures unanimity. In other words, all 9 justices agreeing with one another. I should note that we have not always had 9 justices. We've had as few as 7, as many as 10, but ever since 1869, we have had 9 justices. But what you can see is, in short, throughout the 19th century and well into the first quarter of the 20th century, a fair amount of unanimity among the justices. Much more frequently, you get all 9 agreeing with one another. And what we see is the big dip occurs during the New Deal and the transition from the way the court construed federal power in the 1920s and throughout the early 1930s, and then the famous switch in the mid-1930s from rejecting a lot of the New Deal policies to suddenly approving them, and many others as well. Less unanimity there. But nevertheless, it has retained a fair degree of unanimity, and increasingly so in recent decades. Now, this is just 9-0 decisions. To give you some more comparative sense here, these are 5-4 decisions. This is as close as the court can be in terms of division. And going again back, well, actually, this chart starts in 1936. And what you see here are a real mix of 5-4 decisions. It's just not as common. And so the topmost, the most frequent terms with 5-4 is 30%. So 1/3 at most have been 5-4 decisions. I think that this reinforces the idea that the court really is not as closely politically divided as we might think. Now, I'm going to scroll through. This will give you a way of comparing how often they are closely divided. This is from the 2020 term, and we name each term for the year it begins, although it stretches into the following calendar year. 2020 term begins first Monday in October of 2020. It ends roughly in the last weeks of July for 2021. So of the cases that were reviewed for that term on the merits, the substantive resolution of issues, 29 of them were 9-0 or 8-0. This was when Ginsburg was absent for part of the term, and she was replaced by Barrett. And so that's why we have a few 8-0 and 7-1 cases. But my point is 29 or 43% of all the cases decided that term were 9-0. You add to that the 10 cases that were 8-1, only one dissenter, only two dissenters, and you get a majority of the cases that really are decided by rather lopsided numbers. The 5-4 closely divided, only 8 cases. And that's pretty typical. What we have seen this last term is a bit more of a partisan divide, where the 3 so-called liberal justices versus the 6 so-called conservative justices. We do have a few more 6-3 cases this term, but again, it's not the majority by far. This chart is measuring, and you can't see it because of the screen translation here, from 2020 to 2021, and this past term that's just ended in July. You get the percentage of time each of the 9 justices is in the majority. The justice that's in the majority the least was there. That's Justice Kagan, but also Justice Alito, but they're in the majority 80% of the time. So what does this demonstrate? Even among the helpfully color-coded 3 blue liberals, they're in the majority 82, 80, 84% of the time. Justice Jackson, of course, doesn't have a track record from 2020 and 21, but this shows, I think, that you really do have a court that's more often in agreement with one another in regard to legal outcomes than they are at each other's throats. I think that this gives us a more accurate picture of how this institution really functions. Your impression from reading most media coverage is that this is a politicized institution with left versus right concerns always at the forefront, frequently divided because they dislike or like or prefer particular political outcomes. I think that is only true in a small band of the cases. Alas, these are the ones that you've heard about in the media, but most of their work, they're in agreement with one another. And I think that that's an important impression that we should take away about how this institution functions. The reason I want to emphasize this is because, as you may be aware, public opinion polls of the courts over the years, ever since they've been tracking this since the mid-20th century, the courts have been generally well respected and liked by the citizenry. They always come in at the least 60-some% up into the 80s in terms of approval. The institutions that are least well respected, the presidency, and of course that will vary depending on who's in office and the party. In other words, if it's a Republican in office, Republicans usually respect the office of the presidency much more than Democrats do, and vice versa. This maintains throughout the history of polling regarding the presidency. But the Congress is always below 20%. And so it's notable, the offices that are obviously most politically contentious are the ones that tend to have the most volatility in terms of public opinion. But the courts recently have started to go down in public opinion polls. And I think this is a product of media coverage. And so I don't think that that's an accurate reflection of how the court actually functions. That may cause some questions during the question and answer period. I hope it does. All right, so now I want to move on to some of the big cases from this past term. Probably the one that you know the best because it was decided recently, or it was published recently, is the 2 cases that were joined together. My alma mater, UNC, Chapel Hill, was joined with the Harvard University case. Legally, 2 different cases in terms of the governing law. it's about affirmative actions brought by the same plaintiffs group, Students for Fair Admissions, which is a group representing Asians who have been denied admission to both Harvard and University of North Carolina. The Harvard case is the only one that actually went through a trial where there was a record of evidence about the practices of Harvard. UNC was somewhat similar. The idea was that Asians were being rejected at a much higher rate than other ethnic racial categories. Asians, of course, have a history of performing much better than any other ethnic and racial category. And so the idea was to reject them at a greater rate to make space for other ethnicities or race categories for admission. And so the Harvard case was different from the UNC case because University of North Carolina is a public institution under Supreme Court precedent. That means the 14th Amendment's Equal Protection Clause applies to government entities, and if there is a violation of law, it would be a constitutional violation by the university. Harvard's different. It's a private institution. It would be governed by the 1964 Civil Rights Act, which expressly prohibits any race-based discrimination or national origin or ethnic discrimination for any private entity that receives federal funding. And so the Harvard case was decided not based on the Constitution, but rather on the 64 Civil Rights Act. The outcome was the same, and technically the two cases were different because Justice Jackson, the newest justice on the court, was on the board at Harvard. She recused herself from the Harvard case, but participated in the UNC case. So in one instance, we've got one more justice, but the outcome was the same. It was declared unconstitutional. One of the unknowns that comes out of this case is not just how efforts at race-based or race-related admissions will fare in the future. A lot of proxies are anticipated, proxy efforts, alternatives like granting automatic admission to valedictorians and salutatorians at high schools, no matter what the averages are at those schools. That can increase ethnic admissions. In other words, alternatives in terms of admissions. But one of the biggest unknowns is how this decision and the principles upon which it was based will be applied to other areas of law, like contracting and hiring and promotion decisions, both in the private and the public sector. There have been some proactive efforts on the part of some businesses to say, we're going to try to seek alternative methods proactively before there's a case that's going to challenge these efforts. It's anticipated that this could be a really far-reaching case going well beyond academia and apply to a variety of sectors in America. Another aspect of this, often less well known about affirmative action. When we think of affirmative action, I think stereotypically it relates to race and ethnicity. Affirmative action has also been extremely important and present in the hiring and promotion of women, and how this will apply potentially to gender-based or sex-based hiring practices, promotion practices. We just don't know yet. And so this is why this could really be a watershed case, not in the comparatively narrow area of admissions, but going well beyond it. So a really big potential case that's going to spawn a lot of other cases that the court will likely review. One aspect of this that is really different from the Dobbs case a year ago, which is the abortion case, is that affirmative action publicly is less liked and respected by the general public. That's what these polling results, this is from the Pew Research Center. There are a lot of similar polls over the years about how often or what the degree of public approval is for bases for admission, whether it should be legacy admissions, athletic scholarship admissions, affirmative action, race-based, gender-based. And race and ethnicity is generally unpopular. It's a minority position within the general public, and even among African Americans, it'll vary in terms of different polls, but a majority of African Americans, a smaller majority, but nevertheless a majority of African Americans often disapprove of race-based admissions. And so the reason I point to this is often it is an area of interest for academics about whether the court is following public opinion or leading public opinion. And for example, there's a really vibrant historical debate about whether in the late 19th century with the Plessy versus Ferguson decision about separate but equal, whether that was the court simply ratifying what the rest of society wanted, or whether it was the court trying to be a leading institution, albeit perhaps for the wrong reasons morally, but a leading institution trying to shape public policy. Same question recurs in the 1950s with the Warren Court and the Brown versus Board decision, which reverses Plessy. And the question is the court there trying to shape where the nation's going, or is it merely reflecting a trend in the nation? Same thing, I think, with Dobbs and the affirmative action questions. These will be debated for years on end, but I do think it's pretty clear that public opinion generally already supports this particular outcome from the Harvard and UNC cases. The Dobbs was a little different, much closer in terms of public opinion, but nevertheless, some aspects of restrictions on abortion were popular across the board. And so this notion of the court being a social policy creator, I think, is questionable. In many ways, I think they're often reflecting the general populace's attitudes rather than shaping them. A couple of other big cases. Back in September of 2021, the Department of Homeland Security head Mayorkas had issued a memo that prioritized which kinds of people were going to be targeted for deportation out of the eligible number of those eligible for deportation, upwards of 11 million. That figure may or may not be accurate. It's been used for a long time, but that considerably narrowed those who would be subject to deportation to terrorists, criminals, those who have been convicted of a crime, and those who had also recently been arrested but not yet convicted. These would be the people that were going to be targeted. Texas and Louisiana turned around and sued the administration, arguing that the administration lacked authority to decide which kinds of people were going to have the law enforced against them versus not. This was a victory for the Biden administration, an 8-1 decision. Texas and Louisiana were deemed to lack what's called standing. In short, standing just means that you've got some kind of injury that the courts can redress. If you don't have any injury, you just don't like a policy, too bad, you lack standing, and that means that your interest is not going to be tangibly affected by a court's decision, so you can't bring the case. That was the case in this Texas-Louisiana lawsuits. The response of the court was, you don't have any particular injury as a state, and also you can't simply complain because you don't like the discretionary authority that the executive has as to which kinds of groups within an enforcement category they're going to have the law enforced against. And so kind of a technical decision, but nevertheless pretty important, because obviously immigration policy is of continual interest, and states try to affect immigration policy, even though under the Constitution it's something restricted to federal power. And so this was a limitation really on the state's ability to try to challenge that. Another really big case, an important one, beyond just the parties involved, was the Sackett versus the Environmental Protection Agency. The Sackett couple, which you see pictured here, they bought a piece of property. It was vacant land in western Idaho near the Priest Lake. You see the large lake here and the area of detail reproduced here. The little strip of red is the Sackett property. It had no connection physically to the lake. There was no stream or anything running across the property, but they were told after they bought it that by the EPA that they could not build on it. And the reason is because it was deemed a wetland, which can include floodplains that might be 100 or 500 year floodplains. And so effectively dry land and perfectly eligible to be built upon. But this, under the interpretation of federal law, the Clean Water Act by the EPA, if you designate something as a wetland, the EPA interpreted that to be so closely connected to the waters of the United States, which the Clean Water Act covers, that you then were subject to all of the restrictions on construction in actual wetlands like rivers and lakes. So the purpose of this challenge obviously was the Sackett's wanted to be able to build on their property, but it held a potential to affect the way regulatory agencies in general are able to implement the laws that they are charged with implementing. Just a bit of background, the way the regulatory state works: Congress passes a general law, and the terms that are in the law are subject to being interpreted by the regulatory agency that's meant or charged with enforcing it. That gives the agency a bit of latitude in determining how broad a particular term is going to be, and therefore how extensive the reach of the law is. And so in this instance, the Sackett's win, and they are, it's a 9-0 decision. And I think that's important. Again, it's one example of how the court is unified on its interpretation of the law. This was a basic reading of a statute where the court said waters does not include land that is essentially only in a floodplain that's going to happen maybe once in a century. The idea of, excuse me, the idea of anything other than a navigable water like a river or a lake or an ocean is antithetical to the common sense interpretation of the statute. And so it's a narrowing of not just the EPA's power, but it may signal a narrowing of regulatory power in the future. I'll refer back to this case in a few minutes when I talk about one of the upcoming cases in the 2023 term. Another big case, a politically contentious one, you probably heard about this one in media coverage, is Moore versus Harper. This tested a theory of recent vintage called the independent state legislature doctrine. The idea was that under our constitutional system, state legislatures can create election laws and redistricting for federal congressional districts through the state enactment procedures. In other words, state law applies to both federal elections and state elections. But under the language of Article 1 of the Constitution, it says the manner of holding elections for senators and representatives shall be prescribed by the legislature thereof. The Republican legislature in my home state of North Carolina had created new districts after the 2020 census, as all state legislatures have done. This one was dominated by the Republicans, and they created districts that were going to disadvantage the Democratic Party. And the question was, when Democratic friendly litigants challenged this in federal court, the Republican legislature defended itself by saying the Constitution, by specifying that legislatures get to review this, cuts out any reviewability by state courts. The Supreme Court, in the Moore decision, decided on a 6-3 basis that this independent state legislature theory does not hold water. It does not prevent state courts from deciding whether an enactment violates state law. So this is a victory in the sense, this is a victory for courts in general, because they still have the ability to perform the separation of powers function, the check and balance function, where they are reviewing enactments by state legislatures. It says nothing about the propriety of redistricting. It's always been done, obviously, to advantage the incumbent party. That's going to continue, but whether or not any particular effort violates state law or a state constitution, the state courts can still have their say on that. Another big case, of course, that you've heard a lot about is the Nebraska case regarding the president's program for trying to forgive student loans. This was a 6-3 decision. Again, we've had more of those this term, where the administration was deemed not to have the authority to establish a loan forgiveness program that was essentially a categorical forgiveness program. All of those who were subject to the federal loan guarantees and the supports would not going to be allowed to simply be forgiven across the board. In other words, this is the kind of measure that would really need to be enacted by Congress. And one of the issues in this case was, again, the notion of standing, as in the immigration case that I mentioned earlier. The notion of standing in this case was, is any state or any individual actually harmed by the loan forgiveness program? Regardless of what you think of it as policy, the question was, were any states actually affected by it? There was a program that actually received a degree of funding from managing student loans within the state, and this was in Missouri, and that program would lose money as a result of the forgiveness program, so they were deemed to have standing. There were individuals who didn't like the program who nevertheless stood to benefit from it, and they brought their own suits, and they were deemed to not have standing. And so their suits were unable to go forward because they were not actually harmed. Again, this notion of standing is a really important one that limits the kinds of cases the court is able to consider. Another big case from this past term, 303 Creative. You may have heard of the baking case from Colorado, where the baker, for religious reasons, did not want to bake cakes for same-sex couples to celebrate their unions. That case was decided in his favor several years ago, but that was because the Colorado Civil Rights Commission was so hostile to him in its proceedings. It was not decided based on any First Amendment claim about religious liberty, but rather more of a procedural and enforcement claim that he was simply unfairly treated by the administrative agency that was administering the law in Colorado. That same law, a non-discrimination law, still exists. And Lori Smith, who is the woman you see pictured here, she owns a company called 303 Creative. She's a graphic designer, and she filed what's called a DEC action, or a declaratory action. It's a little bit unusual in terms of constitutional law because she filed this action proactively. She was not being cited by the Civil Rights Commission the way the baker had been, but rather she was asking for the courts to declare her rights under the Constitution in response to her fears that she would be cited if she engaged in business in the way she wanted to. What did she want to do? She wanted to design websites for weddings, and she did not want to be forced or fined for refusing to design them for same-sex unions. So she has religious convictions that dictate in her conscience that she's not going to do same-sex website design. She noted that she, just like the baker, would not refuse someone simply because of their sexual orientation, but rather did not want to create something that celebrated a union that she religiously and politically disagreed with. The court sided with her. They decided this was a First Amendment so-called compelled speech problem, where you're being forced to create speech with which you disagree with. There is a body of case law that indicates that people cannot be forced to utter or print or publish messages with which they disagree. And so this, in many ways, fell in line with that body of case law that says you can't be forced or fined for not endorsing messages that the government wants you to endorse. Another big case didn't receive as much attention as I would have thought. This was the Twitter versus Tomnay case. Back in 2017, there was an attack on a nightclub in Istanbul, Turkey by ISIS. ISIS had, before that attack, published videos on Twitter and other social media in an effort to engage in recruitment of new members. Believe it or not, they have a public relations division of ISIS that gains new membership by using social media around the world. The family members of some of the victims in that nightclub attack sued Twitter here in the US, arguing that Twitter should be liable for damages for allowing the postings on its website. Famously, there's a federal provision from the 1990s called Section 230 that protects businesses that allow people to post on their web platforms. This is different from a newspaper, which obviously any letter to the editor is going to be edited, it's going to be reviewed, and there's a decision on the part of the editors to publish. That's different from a platform like Twitter, wherein people can publish all kinds of material. Nevertheless, social media has taken it upon itself to try to police what is being posted, which raises the question of whether this is a form of editing that would make them liable to lawsuits because they're more akin to a newspaper than they are simply a posting platform or a billboard. But in this case, the court decided in Twitter's favor, noting in a 9-0 decision that there was no actual connection between what Twitter had done, even though they had actually proactively tried to remove videos like the ISIS videos. They could not catch all of them. And so there was not going to be any liability upon the failure of Twitter to police its site effectively. Also, there was no factual connection that anybody who viewed the Twitter videos actually participated in the nightclub attack in Turkey. Another case, I know there was a patent attorney. This is an intellectual property case. The Andy Warhol Foundation had taken some photos. Andy Warhol, when he was alive, had taken this photo taken by a photographer who had taken a picture of the artist Prince early in his career before he was world famous. And this photo was taken by Warhol, who was famous for taking original works by others and altering them in some fashion. These photos would have their own intellectual property protections, but under copyright law, but there was no permission gained from the original photographer for use of the photo in other venues. And this was featured in a magazine article without any credit or any permission from the photographer. And the question legally was whether or not this was allowable under the so-called fair use principles of federal law, where in certain instances, copyright protected material can be used without any type of liability for violating the copyright laws, the so-called fair use provisions. And the court decided this did not fall within those fair use exceptions. In other words, the original photographer or artist or creator had to be credited and give permission before this could be legally used by the Warhol Foundation. So potentially far-reaching decision within an area of law. Doesn't get a lot of coverage. It did get some coverage simply because it dealt with Prince, but if it had been somebody else, it probably wouldn't have gotten much media coverage at all. This, I think, is a good example, however, of a couple things. Number one, it's a 7-2 decision, not a lot of dissent here. It is an example of an important decision in an area of law that will affect many people in terms of what kinds of usage of copyrighted material is going to be available going forward. But it's not something that's deemed politically contentious, and therefore it's not going to get a lot of media coverage. All right, I think this is the last one, or next to last, that I have from this past term. This is a really interesting case, National Pork Producers Council versus Ross. California had enacted a law that required sows to have 24 square feet of space in their pens. That is larger than any producer of pork in the industry has. The pens are much smaller on average. So the purpose behind the law was to reach beyond just California, because very little pork, very few sows are housed in California. They're housed throughout the rest of the country. And the effort that California was engaging in was going to arguably, because it's such a big market, there are almost 40 million people living in California, and it's a big market for pork. And so if the pork producers had to abide by the California standards, that meant that the entire industry would have to change its housing standards for pigs. And so they sued, claiming that this violated, for the lawyers in the room, no trauma intended, to refer you back to your law school days when you had to learn about the Dormant Commerce Clause. But this was a notion that even though states have authority to act in certain instances, like regulating the products that are sold in their state, if those regulations effectively harm an objective that Congress has created through its laws, or an effort to regulate an entire industry beyond the state's borders, that can be declared unconstitutional as violating the Dormant Commerce Clause, meaning Congress is the only entity that would have authority to make such a law rather than simply a state doing so. California won this case. And the reason they won was because their law applied uniformly to both in-state producers, even though there were very few of them, and out-of-state producers. In other words, there was no discrimination. The classic reason for the Commerce Clause being used to strike down state law is because of protectionism, where one state wants to protect another against imports, so they protect the home producers. That's pretty typical. It's been one of the original reasons the Commerce Clause was created back in 1787. But the flip side of that has been, can a state reach beyond its borders to regulate an entire national industry? It's notable, California here has a bevy of inspectors. Their jobs were created by this law. They don't inspect just California. They go all over the country to inspect hog production facilities throughout the country. And that's a requirement of the law. A lot of people thought this case was going to go the other way, that the California law would be struck down. But the court decided that since there was no discrimination, the law would be upheld. And so if you want to sell pork in California now, you've got to comply with its statute. Will this change the hog industry overall? The hog industry said it was going to change it. We don't know yet. Another case, really important one from this last term, is the Holland versus Brackeen case. This is actually a complex case because it had to deal with a lot of issues legally that were pretty important before the case could be heard on its merits. But suffice it to say that this was a case that dealt with the U.S. government's relationship with Native American tribes or Indian nations. Ever since the 1830s, famously, with the Indian removal policies of different states like Georgia and South Carolina, there's been a question about what power states have versus what power the federal government has in relationships with Indian tribes. This dealt with the federal law called the Indian Child Welfare Act. One of the purposes of a lot of federal law since the 1960s has been to eradicate the approach that the American government took to Native Americans prior to the 1960s, especially in the late 19th and early 20th century, where they tried to forcibly assimilate Native Americans into what they considered the broader Anglo-American culture. That is, you would take orphans or children that were removed from Native families and put them in white-run schools in order to acculturate them to the majority white population. This was seen as a kind of ethnic cleansing, or at least a kind of effort to eradicate a Native population's culture. And so in the 1960s, one of the laws that was enacted to remedy this was the Child Welfare Act. What it does is requires that for children that are removed, say for an abuse or neglect situation, if the children are removed from a Native American home on a reservation, they have to be placed with either a Native American family member or placed in a Native American foster home rather than a white or other ethnicity foster home. The theory being you preserve the culture for this child that's removed. This was challenged under the basis or on the claim that this violates the 14th Amendment's Equal Protection Clause. In other words, it's a race-based allocation of where these kids go that should be deemed to violate the 14th Amendment. Also, the 5th Amendment, even though it doesn't actually have an Equal Protection Clause, there's an equal protection component according to the court. And so this was challenged under that. The court decided that this did not violate the equal protection provisions of the Constitution, and therefore these ethnic-based allocations are going to continue. This was another 9-0 case. Axon didn't get a lot of media coverage, but it's actually pretty important. This is a case that consolidated two cases that were coming from administrative agencies where the method of appointment for the administrative judges, sorry about that. Okay. The method of appointment for the administrative judges was being challenged by the parties. Now, this sounds like inside baseball, pretty technical. The reason it's important is because in the administrative agency process, whenever an agency tries to implement a regulation, if it's going to be challenged, it will usually be challenged in the agency itself before it goes, if ever, to the federal courts. That step is an extra step of litigation that's very expensive. And in this case, both of the parties here were challenging the method of approval or appointment for judges. That in and of itself is less important than the idea that they wanted to challenge it before their cases had ever been reviewed at the agency level. They wanted to go to the court first, the federal courts first, so that they could nip the litigation in the bud if the appointment of the judges was improper. Why does this matter? They win in the Supreme Court, and the reason that their victory can have far-reaching effects is because it allows for challenges to agency actions in the federal courts before people have to go through the agency process. Why does that matter? Because it's really expensive to litigate against the agency. There's usually an 80+ or at least 70+ % victory for the agency by these in-house judges. They usually decide in the agency's favor. And by that point, the financial resources of the litigants are usually exhausted, and they don't even have the funds to go to the federal court to further litigate it. So this is really a victory for those who are concerned with federal agency power, because it potentially allows a short-circuiting of agency enforcement efforts by the federal courts, so that they don't have to exhaust their resources through the agency process. All right. A couple of cases, and then I'll open the floor for questions. Some of the big cases coming up. Probably one of the most far-reaching cases is the Loper-Bright case. Under the regulations of the Federal Marine Fisheries Agency, there are compliance requirements for how you conduct your fishing operations, the weight of the fishes you keep, what kinds of stuff you have to throw back, et cetera. How does the government monitor compliance? They have literally physical monitors come on people's boats, go out with them, monitor how they fish, and take notes and make recordings. Under the regulations promulgated by the agency, there's no provision for how these monitors are paid. The agency doesn't want to pay for them, so they've required the fishermen themselves to foot the bill for the salaries. Well, there's no statutory authority for that. And even though there are instances where Congress has said a regulatory entity can force the entities that are regulated, the private sector entities regulated, to pay for certain monitoring services, in this case, under this federal fisheries law, there was no congressional provision for that. And so the agency itself decided, under its own interpretive authority, that it would implement this provision. That's what's being challenged in the court. Now, this is important for the fishing industry, obviously, but what's important about this case and why this could be a truly watershed case is because the court has expressly told the parties it will, as a court, review what's called the Chevron doctrine. Chevron is a case from the 1980s, named after a case involving the oil company Chevron. That case, the details of it are unimportant. It's the so-called doctrine is courts need to defer to agency interpretations of statutes. That means, as a practical matter, that lower federal courts, and including the Supreme Court, have, ever since the 1980s, been very deferential to agency interpretations of statutes. That gives a great deal of latitude to the agency to interpret words in the statute, similar to the Sackett case, where the EPA told the couple they couldn't build. They interpreted the word waters very broadly. The court nixed that interpretation. But in that Sackett case from this last term, the court didn't really address the Chevron doctrine as a principle or a key holding in the court's jurisprudence, but that's what they're going to do in the Loper-Bright case. I think this is going to be one of the biggest cases in the upcoming term, because if the court's willing to address it, I have a suspicion that they're looking, or at least several of the justices are looking to overturn that Chevron doctrine. If that were to happen, if Chevron were to be overturned, that would mean, arguably, that courts in the future would be less deferential when agencies interpret ambiguous terminology in a congressional statute, which could start to narrow the breadth of the agency's regulatory power. So this could really be a watershed event, no pun intended, in the administrative state and the way it's governed. Another case that's coming up this coming term is going to be the South Carolina NAACP versus Alexander. This is an equal protection case that's dealing with the redrawing of maps. Redistricting cases often come to the courts in the early years of a decade because every decade we have a new census that allows for the redrawing of congressional maps. In South Carolina, which has a large African-American population, which historically throughout the U.S., African-Americans vote 90+% in favor of the Democratic Party. If you've got redistricting by the Republicans that harms the Democrats in a southern state, it's usually going to have obvious race-based recategorizations in terms of how the district is redrawn. The NAACP is challenging this redrawing by the Republicans as racially motivated. The Republicans' defense is effectively, no, this has nothing to do with race. It just so happens that the districts obviously involve majority minorities and meaning African Americans. And therefore, if we're going to redraw it in a way that is admittedly preferable to our party, it's going to involve African Americans being recategorized or divided in different districts. So the question that's coming to the court is whether or not this is going to be a race-based, impermissible redistricting, which could be a qualification on how redistricting is done in the future. Bear with me one second. Vidal versus Elster. This is one of my favorite cases coming up. You may recall in 2016, one of the presidential debates, Marco Rubio mentions the size of President or candidate Trump's hands. And this is the moment from that when he holds up his hands, obviously implying something about him as a result that he has small hands, which must mean something else about him. Well, only in America, right? Steve Elster, innovative marketer, decided he wanted to trademark a t-shirt, and he wanted to get this approval from the Patent and Trademark Office, federal office that can approve trademarks for use across the country. Trump too small. That's the phrase on, it's hard to see it here, Trump too small, and it's got a picture of a hand doing this. And it says on the back of the t-shirt, Trump's package is too small, and it lists all these policies that are too or insufficient. In other words, this is a guy who was critical of Trump, and he wanted it trademarked. Well, under one of the regulations, federal regulations, there's a policy of prohibiting registration for a trademark that uses the name of a living person without their permission. And so one of the questions the court is going to address is whether or not this is a whether this action by the Trademark Office to refuse registration of this mark was allowable. Elster, the designer of the t-shirt, says the reason they disallowed it was because of his political views of Trump. In other words, he was critical of Trump, and this is a matter of political speech on his part, which should overrule the prohibitions in the regulations. In other words, this is a First Amendment free speech case. Somebody who's critical of Trump is being denied the ability to have this mark registered because of that. So that should be an interesting case. May not be a earth-shattering case in terms of legal precedent. It could affect intellectual property law, but it'll probably get a lot of media coverage, of course, because it's dealing with Trump. Another case, and this will be the one I end with, and then I'll open the floor for questions. The Constitution allows direct taxes that are, quote, apportioned among the several states. In other words, in proportion to the state's population. One exception to that is the 16th Amendment, which allows the taxing of income without regard to proportionality. Now, in 2017, the Tax Cuts and Jobs Act allowed what was called a mandatory repatriation tax, which for any shareholders that own 10% or more of a corporation or a company, they had to pay a tax on the corporation's retained earnings, even though dividends had not been distributed. In other words, you were paying a tax calculated on funds held by the company, never distributed to you as an individual. And so the question that's coming before the court this term is based on a couple that you see pictured here, the Moores. They own 13% of an Asian Indian farm equipment company. They reinvest all their earnings. The idea is to make farm equipment available to Indians as cheaply as possible, to allow for advanced technology to be implemented in farming methods in India. And they had to pay upwards of $14,000 in tax for money they had never received via any dividends. They're challenging this as an unconstitutional taxation. Why does this matter? It sounds like it was a one-off in a 2017 law, because there are proponents, and some of them in Congress now, who want what's called a wealth tax. A wealth tax would go beyond realized income to evaluate all kinds of things in which you have an interest and potentially could have realizable income in the future. And so this is going to potentially test the constitutionality of the idea of a wealth tax. In other words, do you have to have realized gains in order to have a constitutionally applicable tax? Sounds like a technical question, but it could apply to all of us potentially in the future. All right, so there are other cases that are coming up, but I'll end with that. I know I covered a lot and I did it quickly, but hopefully this generates some questions. So I'll open the floor for questions now.
Thank you very, very much. What a fascinating presentation.
Yes, sir.
I'm going to preface this with if, since I'm not a lawyer. If the Constitution means that restricts the federal government, restricts the federal government, and anything not specifically in the Constitution is resolved from the states, does the collective interpretation of the Second Amendment mean that the states could infringe on the right to bear arms where the federal government can't?
Okay, so the question, I don't know if everybody heard the question is, if there's not a power expressly in the Constitution regarding particular powers of the states, and what you're referring to is really the 10th Amendment, which reserves matters that are not specifically given to the Congress as a power to the states as a power. Alas, what has happened over the 20th century, especially since the New Deal, is that one particular provision, several provisions in the Constitution have allowed an expansion beyond that enumerated powers. The Commerce Clause has been interpreted to allow all kinds of powers to Congress if they, in some fashion, affect interstate commerce. A classic example of this is the 1964 Civil Rights Act. That was allowed because it obviously can affect interstate commerce in terms of people being able to travel and being refused service because of their race. And so that's an example of a morally praiseworthy law that nevertheless has a rather thin reed of constitutional legitimacy based on the Commerce Clause. The Spending Clause, the General Welfare Clause, and the Tax Clause have all been interpreted pretty broadly to allow a lot of powers. Now, you asked about the Second Amendment in particular. The Second Amendment had very few cases before 2008. The famous Heller versus DC and the McDonald case coming out of Chicago suddenly gave life to the Second Amendment in terms of being able to potentially thwart state regulatory efforts. And we have had some challenges. In fact, there's one of the cases I didn't talk about that's coming up before the court this term is whether or not a state's prohibition on allowing those who have had restrictive, I'm blanking on the term, when your wife says you're beating her and you got an order against you to not go around her, I've forgotten the name for it, but the restraining order. If a restraining order can be utilized to prohibit the possession of a firearm under the Second Amendment. So ever since that 2008 case, which breathed life into the amendment for potential challenges, there have been efforts to, on the part of pro-regulatory efforts to restrain access to guns and other efforts to challenge it in the courts. And so I think this is an ongoing battle that will continue for the foreseeable future, because even Scalia famously in his Heller decision said, this doesn't mean people can go out and buy a bazooka. And so the degree of state regulatory power, I think, is going to be constantly challenged in the courts. And I don't know if there's going to be a bright line that's drawn by the courts that said this is what states can do versus what they can't. I hope that answers your question.
Online, Elliot?
Thank you for a most interesting talk. You used the term merit several times. Does the law have a legal definition for the term merit, or at least an objective definition for the term merit?
Okay, so I referred to addressing cases on their merits. The court will tell the parties often how they want to address the legal issues, and they'll require that the parties come to them, regardless of what the parties want to do, how they wish to address issues or what kinds of legal issues they want the court to decide. Sometimes the court will shape that for the parties. And when the court addresses the legal rights and liabilities of the parties, that's considered judging the case on its merits. There are procedural issues that courts and other government bodies have to comply with, which sometimes means that the case is not addressed on the merits, but rather on procedural issues, which effectively can decide the case, but it doesn't necessarily shape the substance of the law. One example of this would be the baker's case from Colorado I referred to, the baker who did not want to bake for same-sex weddings. That was decided because of some of the procedural unfairness that happened at the administrative level back in the state. They did not address the so-called merits of the case by deciding whether there was a free speech or free exercise of religion right that the baker possessed. So that's an example of not addressing the merits, but still resolving a case based on some procedural issues.
Thank you. Thank
Yes,
you for your talk. Very interesting. Since the Dobbs ruling, the Planned Parenthood, the Jackson, all those rulings a year ago, we've seen a real havoc in the healthcare in this country. A lot of misery among people who do not have access to abortion. My question, I mean, it is a terrible situation. I follow that rather closely. I was wondering, does the court, before making such ruling, does the court anticipate such repercussions? And my second first question is, we have been talking about increasing the number of judges from 9 to whatever. Yeah. And in your own crystal ball, do you think such ruling would have been prevented had they had been more judges on the court?
Okay, two big questions. The first question about whether the court collectively anticipates the consequences of a decision. The short answer to that is usually yes. Sometimes justices profess that they're adhering to a principle regardless of consequences. And I think that whether it's conservatives or liberals, when they're approaching an issue, they often do think about consequences. Doesn't mean they are accurate in their assessment or predictions about what is in fact going to happen. But I think consequences often weigh on the court when they're making their decisions. And litigants know this. So the strategies for lawyers who argue before the court, both in written form and orally, they often strategize. Their tactics are crafted in a way to appeal to the sensibilities of justices. If you do this, X is going to follow. And so I think it's a certainty that consequences matter. But again, what a conservative thinks are going to be the consequences versus a liberal will often be completely different, right? And sometimes it's wishful thinking about what the consequences will be. So we don't always know. I'll give you an example of how things were not entirely predicted. Back in the 1960s with the so-called one-person, one-vote cases, the redistricting at congressional districts and whether or not it had to attend to some kind of balance in terms of the populations in one district versus another within a state. it was anticipated that this would result in more power to urban areas because of the population concentration within urban areas. It turns out, and this was presumably a political goal of the Warren Court. This is the early 1960s. Well, it turns out the redistricting cases actually favorably affected many conservative areas in outlying areas in suburban areas. A consequence utterly unanticipated. Nevertheless, it was flowing from this decision. It rejiggered the incentives for how you drew your districts, and it affected favorably Republicans rather than Democrats. You don't know how this stuff is going to turn out, and so it's a crystal ball that's difficult to implement. If there had been, your second question, if there had been more justices on the court when Dobbs was decided, would it have been decided differently? Arguably, yes. It's a numbers game for the Dobbs decision. It was obviously a left-right divide. It's one of those examples that runs counter to what I've been suggesting, which is a less politicized court. That was an example of one that's very much a reflection of political ideology. So if you'd had more justices, arguably, yeah, you could have had a different outcome.
Thank you. I remember in my law school class 100 years ago that our constitutional law professor said that the statistics basically that you gave about 9-0 decisions and all of that, the unanimous and near unanimous decisions were for the most part contract cases, the typical stuff you see litigated, estate matters, things like that, corporations suing corporations. But the political cases are different. So I'm wondering if you take out of your equation of the near unanimous cases, all of those routine stuff, and you just look at the Dobbs case, the federal agency cases, the gun case, all of these cases, I wonder what those statistics would show, whether or not the partisanship is really current and existing today as it was in the 1960s and 70s.
That's a good question. There's a lot, and it's ongoing work, especially as you get new justices added, of how you should assess the political divisions in the cases. Why do judges or justices vote the way they do? Sometimes you don't know because they're not writing a concurring opinion. You don't know the substance for the reasons why they agree. Presumably, they agree with whatever is in the opinion. And also, famously, the court has, this was arguably one of the reasons that the Dobbs opinion was leaked, there's politicking within the court. So there can be an initial vote when the court takes a vote. The way the court operates, you might hear a case on a Monday or Tuesday. That Friday, they take their initial vote in conference. It's only the 9 justices. None of their clerks are with them, and they know what the initial vote is. Now, of course, their clerks are going to learn this pretty quickly because they have to go research and draft an opinion in accord with what the justice wants. But that initial vote can change over time. The most famous, or one of the most famous examples of this, is Brown versus Board. Brown versus Board could have come out earlier than 1954, but the personnel was different on the court. Eventually, Earl Warren comes on, and former governor of California, he wants a unanimous court. It wasn't going to be unanimous initially. It was probably either 6-3 or maybe 7-2. There would be dissenters, and Warren was convinced that if there were any dissenters for this decision, there was no mystery about who was going to win, but if there were any dissenting opinions, he saw those who did not want to desegregate the schools as having something to point to and latch on to and utilize in their political arguments. If there was a 9-0 decision, no dissents, that could be more politically powerful for the civil rights movement. That's an example of lobbying within the court, because he went to each of the justices and convinced those he saw as leaning toward the other side to come over and make a statement for civil rights. This happens a lot. We don't always know how often it happens. We don't know what happened in the Dobbs case, if there was any true switching of votes in that. But your question is pertinent to, understanding the court. And again, this is one of those institutions we don't have a lot of insight into. Bob Woodward came out with the Brethren back in the early 80s, late 70s. That was one of the, that was a seminal work. Whether you trust Woodward's account of things or not is different, but that was an example of where the clerks and former clerks actually talked to somebody outside the court. That hadn't happened before. So you didn't have these insider views. And we still don't have a regular, reliable way of understanding how votes are taken, why they're taken in the court. We just ultimately get that final product. But I think your law professor was correct in one instance, which is, yeah, the really salient cases, you can see the left-right divide. But I disagree that the 9-0-8-1 cases are a bunch of technical cases. I don't think that's true at all. Some of the cases I referred to today, pretty important, and they were decided by lopsided majorities. It's not always in the majority a block of conservatives or liberals versus a block of liberals with one or two missing. No, you'll get strange bedfellows where you have a liberal and a conservative dissenting from a liberal and conservative majority. And this happens a lot. So I see those lopsided cases as being pretty politically important. Again, though, I fully agree with you. The big contentious issues, abortion, affirmative action, that's where you're going to see the clear left-right divide.
One last question, Jim Blinn.
Yes, Jim Blinn. My question is, recently the Supreme Court told Alabama that they had to change their redistricting. And Alabama said, okay, we'll change it. And they did, but they didn't change it the way the Supreme Court asked them to. They said to give them the second minority district. And the governor went ahead and signed the law. And so tell me about what you think is going to happen when it gets back to the Supreme Court.
Well, that's a good question. How often does the court have to police its decisions? And we've seen historically the court has sometimes taken it upon itself. It will effectively take on a project where for the foreseeable future, it will try to take an initial decision and continue to make an enforcement set of rulings. A good example of this was Brown versus Board of Education back in '54. For about a decade after that, all these cases that challenged other aspects of race-based divisions like swimming pools, country clubs, public parks, etc. Literally, they would issue these short per curiam opinions where you didn't have a particular justice writing the opinion. It was for the court itself. And they would say, see Brown. And will they do that in the future for something like the Alabama case? If the court thinks it's effectively being dodged, if there's some kind of resistance program against it, I think the court is much more keen, the majority at least that favors that policy, they'll be much more keen to accept cases and put them on the docket and basically say, we meant what we said originally. You see the anticipation of that in the affirmative action ruling. Chief Justice Roberts basically said, effectively, don't try to dodge this with alternatives. And so I think it will be interesting to see the different innovations that universities try to create where they will try to achieve the same result, whether those are going to be successfully challenged and the court's going to hear those. I have a feeling they will. And so if the court wants to try to police its decisions, it can. Other times, effectively, it doesn't make the effort to continue to pursue a principle. Thank you.
Everybody gets 3 credits. Professor, that was a great presentation. We thank you very, very much. And we're going to give you another certificate of appreciation signed by John Dory. And our second way of, I should say, there is an orchid, and the orchid is because in 1930, when the Old Guard was founded, Summit was the orchid capital of the country. Our other way to say thank you is the Old Guard salute. Okay.